Income tax, an excise, not a direct tax, an SA. Most people assume that income tax is a direct tax on their earnings. However, documented legal evidence tells a different story. The income tax in the United States is an excise tax, meaning it applies only to specific taxable events or activities rather than being a general levy on all income. This distinction is not a new or radical interpretation. It has been repeatedly confirmed by the Supreme Court, legal journals, and even government officials. Despite this, common misconceptions persist, fueled in part by misleading statements from tax authorities. The legal foundation: income tax as an excise. Understanding the nature of an excise tax is key. Unlike direct taxes, which must be apportioned among the states based on population, excise taxes are indirect and levied on specific privileges or activities. The Supreme Court has consistently reaffirmed this classification of income tax. In Brushaber v. Union Pacific R. Company, 240 U.S. 1, 1916, the court ruled, taxation on income is, in its nature, an excise, entitled to be enforced as such. The ruling further clarified that the 16th Amendment did not create a new power of taxation but merely removed apportionment restrictions for certain types of income. The court warned that misinterpreting the amendment as allowing a direct, unapportioned income tax would create radical and destructive changes in our constitutional system. This point was reiterated in Stanton v. Baltic Mining Company, 240 U.S. 103, 1916, which stated, The provisions of the 16th Amendment conferred no new power of taxation but simply prohibited the previous complete and plenary power of income taxation possessed by Congress from being taken out of the category of indirect taxation to which it inherently belonged. Similarly, Stewart Machine Company v. Collector of Internal Revenue, 301 U.S. 548, 1937, reinforced that all federal taxes fall into two categories: direct, which require apportionment, and indirect, which must be uniform. Congress, legal scholars, and government experts agree. This interpretation is not limited to judicial opinions. Scholars and legislative experts have consistently acknowledged that income tax is an excise. The Cornell Law Quarterly, 1915 to 1916, states, the 16th Amendment does not permit a new class of a direct tax. The amendment does not treat income taxes as direct taxes but simply remove the ground which led to their being considered as such in the Pollock case. The Harvard Law Review, 1915 to 1916, similarly noted, the amendment was a declaration that an income tax is indirect, rather than an exception to the rule that direct taxes must be apportioned. Even the Treasury Department acknowledged this distinction. Former legislative draftsman F. Morse Hubbard testified before Congress in 1943. The income tax is an excise tax with respect to certain activities and privileges which is measured by reference to the income which they produce. The income is not the subject of the tax, it is the basis for determining the amount of tax. Income tax liability, a privilege-based assessment. If income tax is an excise, then liability must be based on engaging in specific taxable activities or privileges, not merely receiving income. This principle is supported by multiple Supreme Court cases. Flint v. Stone Tracy Company, 220 U.S. 107, 1911, established that excise taxes apply to the exercise of privileges. Thomas v. United States, 192 U.S. 363, 1904, also confirmed that excise taxes are levied on specific activities rather than general property or earnings. If income derived from unprivileged activities were taxed, it would constitute a capitation tax, which is prohibited unless apportioned. In Pollock v. Farmers Loan and Trust, 157 U.S. 429, 1895, the court cited Adam Smith's Wealth of Nations, stating, the most generally received opinion is that, by direct taxes in the Constitution, those are met which are raised on the capital or revenue of the people. The right to work and earn a living has historically been recognized as fundamental. In Butchers Union Company v. Crescent City Company, 111 U.S. 746, 1883, the concurring opinion stated, the right to follow any of the common occupations of life is an inalienable right. Similarly, in Coppage v. Kansas, 236 U.S. 1, 1915, the court ruled, included in the right of personal liberty, is the right to make contracts for the acquisition of property. The Tennessee Supreme Court in Jack Cole Company v. McFarland, 337 S.W.2D 453, 1960, reinforced this by stating, since the right to receive income or earnings is a right belonging to every person, this right cannot be taxed as a privilege. Apportionment and the constitutional limits on taxation. The U.S. Constitution strictly limits direct taxes. Article I, Section 9, Clause 4 states, No capitation, or other direct, tax shall be laid, unless in proportion to the census or enumeration herein before directed to be taken. Despite claims to the contrary, the 16th Amendment did not alter this fundamental restriction. As Knowlton v. Moore, 178 U.S. 41, 1900, clarified, direct taxes bear immediately upon persons, upon the possession and enjoyment of rights. Thus, the income tax, as currently applied to all earnings without distinguishing privileged activities, raises serious constitutional concerns. Misrepresentation and enforcement of income tax. Despite the clear legal precedent, the IRS and some courts have misrepresented the nature of the income tax. For example, United States v. Francisco, 614 F.2d 617, 1980, falsely claimed that the 16th Amendment took income tax out of the class of excises, duties and imposts and placed it in the class of direct taxes. Even the IRS website has perpetuated this falsehood, stating, the 16th Amendment authorizes a direct non-apportioned tax upon United States citizens throughout the nation. United States v. Collins, 920 F.2d 619, 1990. This contradicts Brushaber and decades of Supreme Court precedent, highlighting the extent of misinformation surrounding income tax enforcement. Conclusion. The historical and legal record is clear. The federal income tax is an excise tax, not a direct tax. It applies only to certain privileged activities and must be interpreted within the limits of constitutional taxation powers. Despite efforts to obscure these facts, Supreme Court rulings, legal scholarship, and government records confirm that income tax liability is based on engaging in taxable privileges, not simply earning a living. Understanding this distinction empowers individuals to ensure their tax obligations align with the actual law, rather than misinterpretations propagated by tax enforcement agencies. Now that you know, what can you do? What can now that you know the truth? You have the power to make sure the IRS processes your taxes correctly. Many people have already used this knowledge to file their tax returns the right way, based on what the law actually says. Want to learn more? You can apply to work with us to reassess your taxes, possibly recover money you've overpaid, and even reduce or eliminate unnecessary tax bills. Scan the QR code or visit https://bit.ly/taxtrustcoach to sign up for our tax bulletin and stay informed.